Hello, everyone. There is an ongoing friction between the judiciary and the central government on the issue regarding judicial appointments. Several government functionaries, including the law minister and also the vice president, they have been repeatedly criticizing the Collegium system and also the Supreme Court judgment which overturned the NJAC. On the other hand, the Supreme Court, on the judicial side, has expressed displeasure at the central government not acting promptly on Collegium recommendations. So in this backdrop, we are having a discussion with eminent lawyer, Mr. Arvind P. Datar, senior advocate, on various issues. Welcome, sir. Thank you for joining us.
Morning, good morning. Thank you for having me on your. I've been always admiring your LiveLaw coverage. Wonderful work being done by you. Thank you.
Thank you, sir. Thank you for your kind words. So at the outset, do you think that the Collegium system, with all its flaws and limitations, do you think the Collegium system is the best available system for appointment of judges?
Undoubtedly so. I've had the opportunity of now practicing for almost 43 years. So I've been in the bar before the Collegium system and I've been in the bar after the Collegium system. So I know, I have a rough idea of what was the appointment process before and after. I think that overall, the Collegium system combines the best of both worlds. I mean, you have a proper selection. If you take let's take a High Court judge's appointment. The Collegium at each High Court selects the best possible candidates, keeping in mind diversity, gender, other things, and then they select the best possible candidates for the vacancies. It's a tough task to persuade some eminent lawyers to also accept the judges. So after all the hard work is done, the High Court recommends it goes to the Supreme Court. Supreme Court considers it. At the High Court level, again, they take the comments from the executive. At the Supreme Court level, they take comments from the executive. So if you see it very, very carefully in granular detail, you'll find that the Collegium system actually gets the views of both the executive and the judiciary. All it says is that once the name goes to the executive, objections are there, and the objections are to be sent to the Collegium. If they overrule the objections, if they consider the objection, then the appointment should go through. That's the only point where they say judges have the last word. But in terms of selection of the best possible candidates, taking the views of the executive, because the picture projected is that we are the only country where judges appoint judges. It's kind of a closed club where judges decide the ultimate, which is completely false, which is not the truth at all. There is a huge role for the executive to play, and I know many cases where the executive has objected and the name has not gone through.
Right. So one criticism which has been leveled against the political system is that it is not something which is mentioned in the Constitution, and it is something which has been artificially invented by the Supreme Court through some interpretation. So how do you see this criticism?
Well, I don't think the criticism is justified. First of all, on artificial invention, basic structure has been quote-unquote artificially invented, but that has saved the Constitution for more than once. I think the Collegium system also has, you call it invention, but it has saved the judiciary in my opinion. Because if you see the kind of executive pressure that was brought to bear, you see the supersession of judges, then the transfer policy in emergency, then the famous letter of Shiv Shankar in 1980. There's always been an attempt to browbeat the judiciary for some reason. So now coming to artificial invention, I don't think it's correct. If you see Article 124(2), what does it say? It says the President shall appoint the judges in consultation with the Chief Justice of the Supreme Court and the High Courts. So the appointment, the last word is with the President, which is the executive. Consultation is with the Supreme Court and High Court. Now, if you apply your mind, what is the meaning of consultation? Who is the best possible person to recommend good people from, say, Kerala High Court or Madras High Court or Calcutta High Court? The judges of that court itself. So what is this consultation? This consultation is, in theory, the President asks the local High Courts and the Supreme Court, which are the good names, and they are normally appointed. Now, there is no question of artificially, ultimately, whichever system you have, if all of us are on the same page and we want to get the best possible talent to man the higher judiciary, keeping in mind the requirements of a multicultural, multi-religious country like India, if our intention is to get the best possible candidate, and if merit is the main criteria, then there should be no difficulty. Then whether you have Collegium system or any other system, it will work. What has happened earlier is, if you want loyalty and other considerations to prevail over merit, then all the problems start. So you can always find fault with Collegium, I can find fault with the executives. Take, for example, England. The Lord Chancellor is a minister, he's part of the ruling party. But nobody can accuse the English judiciary of being selected on grounds other than merit. That's why it's respected throughout. That's why 1 out of 7 cases in England, both the parties are not English. Yeah. Yes. So if your aim is to have an independent, robust judiciary, you will not fault the Collegium system. Yes. And other thing I'll tell you, on when you say about the best possible system, I argued the case among the other people, is there any empirical data to say that you take a sample of 100 judges appointed in the pre-collegium and 100 in the post-collegium? Is there any empirical data to show that the judges are substandard now? I don't think so. I don't think so at all. And in fact, at least from the Madras High Court, I know, when 17 names went by Chief Justice Collegium, they just were stalled because the executive wanted their own names there. And to the credit of Justice Collegium, he stood firm. Ultimately, we moved a PIL. Sri Venugopal appeared for us. And the appointments came through. 17 excellent judges. So Collegium has, in number of cases, worked very well in my view. There will always be aberrations. That doesn't mean you junk the whole system.
So you just mentioned that from the standpoint of a robust and independent judiciary, Collegium system is important. But do you think that the Collegium system has been really been able to secure the independence of judiciary? Because we have seen certain instances of certain names which are perceived to be unfavorable by the executive. They are not recommended, they are overlooked. And also we have also seen certain names with open political affiliations being recommended as well. So do you think that the system has been able to secure the independence of judiciary?
See, frankly, the independence of the judiciary can be secured by the executive respecting the recommendations of the collegium. Ultimately, the last word is the executive. The president has to sign the warrant. If he doesn't sign the appointment of an excellent candidate, what do you do? So at whose altar is the independence being sacrificed? At the collegium altar or at the executive altar? If, take for example Justice Qureshi, for example. What was the justification in not appointing him to the Supreme Court? Did the Supreme Court could be faulted for recommending his name or mentioning that he should be appointed? Now, for example, you recommend another name of a person who should have come to Supreme Court. That is taught for 6 months, 8 months. Some names are approved in 48 months. I'm saying High Court and Supreme Court. When I say Supreme Court, I mean the overall place. So, then what's the message you send? So I think it is wrong to blame the collegium for independence. Collegium has got nothing to do with independence. Collegium makes the best possible recommendations with its own limitations. In fact, I was told that Qureshi was not recommended, but my point is this. The collegium can only go so far. The independence can be secured if the executive respects, yes, these are excellent candidates. Merit is important and I will appoint them.
So another major criticism against the collegium system is that it appoints people who belong to a particular network or a particular group. And most of the recommendees are either relatives of judges or senior advocates. And there is also another criticism that there is not sufficient representation of backward classes and minorities. So it's not representative and inclusive enough. That is one criticism which has been leveled against collegium system. So do you think that a system like NJSC, which would be a constitutional body, which would be open to public scrutiny, do you think that such a system would ensure a more accountable, representative, and inclusive system for judges' appointment?
Well, it's a very, your question has multiple parts, so I'll take them one by one. Now let's go to this aspect of, you didn't use the word nepotism, but what you meant was children and relatives of judges get appointed. See, I tell you, I have no quarrel with the son or daughter of a judge being appointed if he is meritorious. Very often, a child gets to the law because his parents are lawyers. He has grown up in a family of lawyers. So traditionally, whether it's a lawyer or a doctor or an architect, very often the son follows the father's profession. That's very, very common. You see it more in politics. I mean, it's ironical who's accusing the judiciary of nepotism. You know? But anyway, the fact that he's a son or daughter is not so important. As long as he's good, is good. I know cases where children of judges who are not competent have not got through the collegium. So there are cases both ways. Right? And again, I say always check the data. You'll always find around 100 appointments, 5, 10, 15 may be bad. I mean, it's part of the system. Whether it's NJC or it's a Collegium, nobody can guarantee that only the best of the best will appoint. It's not possible anywhere in the world. So to say that sons, daughters, I say there's nothing wrong if they are good, nothing wrong good. As far as backward classes are concerned, again, I don't think your stand is correct. If you take the appointments throughout, I think the Collegium all over the country are making strenuous efforts to ensure that minority communities, backward classes are all adequately represented. In fact, sometimes it's the other way around. Suppose you are not in the reserve community, it's much more difficult to get into the judiciary in some states. That's also a reality we should not forget. So to say that the backward classes are not represented is factually incorrect. See, again, all of us, we talk without data. There is nothing to show that in a high court, there is none. Now, you also can't have proportionate representation. You can't say that because one backward community is 18% of the particular state, 18% or 20% judges should be for. It should be reasonable representation within the parameters. On a state like Madras has 70 judges. I think the representation is excellent. In fact, we've got a very large contingent of women judges also. So to say that backward class are not represented is not correct. You take, I know of Hyderabad, Madras, Bombay, Karnataka, etc. Take the appointments, see the parameters, see the caste factor or backward class factor, etc. You will find that representation is more than adequate.
So I was asking, so will a system like NJC, so it would be more open to public scrutiny? And
see, when you talk of NJC, the present NJC will not select any judge of any point. As I wrote in the article in the Express, it is not workable because of statutory deficiencies. So it has to work. Let us say you have a Judicial Appointments Commission, which has been mooted from time to time. In fact, the word Collegium came in Bhagwati's judgment in SP Gupta, where he said the Chief Justice doesn't have primacy, but a collegium of judges should be formed. So what he meant was consultation. And I think that consultation with Supreme Court judges means consultation with the senior most judges or the group of judges. And what they call in England soundings. Even today, the Collegium gets recommendations from various members, say from the criminal bar. They will ask the judge who's sitting in the criminal portfolio, who's the best possible person. But as far as the NJC is concerned, they will act only on the recommendations of the High Court Committee. I don't think an NJC of 7 members sitting in Delhi will know who are the best possible candidates in Assam or for that matter in Rajasthan. That High Court has to recommend names. Now, once the High Court recommends names and they give reasons, okay, fine, what's his merits? And apart from merits, why is he being recommended? Because of representation of backward classes, gender, minority thing. Then I don't see how an NJC is going to be better than this. And an NJC without the judges in the majority is again going to. And I tell you again and again, you can have NJC, you can have some judicial commission, you can have everything. What is wrong with the Collegium system? Just think dispassionately. Today they are recommending names from a high court. It has got multiple screenings at the local executive level. Supreme Court Collegium examines it. They consult. They've got the consulting judges from the High Court who do it. Names sent by the High Court are not accepted for some reasons, and then it goes to the executive. So there are 3-4 tiers of screening. In fact, what is most important is that today the Collegium system can work very well if you fix definite timelines. Today there is an adequate representation of the executive. Executive opinion is taken into account. You got the IB report. You got so many inputs. Unfortunately, there are no time limits. So a name goes from the Supreme Court Collegium. 4 weeks, 8 weeks, 12 weeks. You take whatever time, but within 8 weeks, you make up your mind. How much time does it take to say that Mr. Manu Sebastian is fit or unfit to be a judge? Does it take 6 months, 3 months? And again, the arbitrariness. Mr. Sebastian gets appointed in 3 days. Mr. Datar doesn't get appointed for 4 months. What is the logic? So if once you have a 4-week timeline, it eliminates any kind of insinuations and systems. And you can have an NJC, as I said earlier. The current is unworkable, but I think instead of having a completely new system with a new thing, the existing system can be made more workable. I mean, has the executive told you that out of 100 names, 30 or 40 are so horrible that the Collegium system has to collapse? There's nothing like that. You take, say, 100 recommendations by the high courts for various judges. How much evidence is to show that totally unfit, unworthy persons have been appointed? It's bound to happen. In fact, what we can do is we can tweak the memorandum of procedure and finalize it.
So
And I'll tell you one thing. If the executive has the final say, you will have a judiciary like that of Russia or other countries, which will not command any respect. Once the executive controls everything, because you require an independent judiciary. Independent judiciary is the most important thing that can happen to a constitutional government. That has been said from Alexander Hamilton onwards. You have a judiciary which is completely independent. You take for England, though there is no parliamentary supremacy, they have struck down some important legislations. I mean, some things have been, not legislations, but processes like, say, for example, the freezing of bank accounts of Iran and all that. That was held to be bad. So many things have been held. So the strongest for a constitutional democracy, see, we have to decide where we want to go. If you want to become like Canada, UK, etc., then independent judiciary is indispensable for that kind of a constitutional democracy. And who does it help by having judges who are only to your liking? Just think for a moment. What kind of a judiciary is that? What respect does it command? How do you attract the best talent from youngsters who want to appear before the courts if they know that the appointments are completely executive dominated? You're causing long-term damage. We faced that after 1973. Why are we repeating it again?
Right. So now recently we have been seeing a lot of critical comments from the government against the Collegium system and the Supreme Court, the judges appointment process, and it has been happening repeatedly. Yesterday also the law minister, he made some statements in the parliament. So why do you think? How do you see this? What do you think this repeated criticism, which sometimes borders on aggression? Why do you think it is taking place? How do you perceive it?
See, according to me, any criticism is welcome in a democracy. Criticism is a must. What saddens me is that the criticism is not based on any factual data or any analysis. If you criticize that the Collegium system is bad because out of 100 instances, almost 45% are bad or 35% are bad, and this system is not working for ABCD reasons, then either you improve the Collegium system or you bring in a law which is constitutional, where the judiciary appoints people. See, even Article 124(2) simply says consultation with the Supreme Court and the High Court. Doesn't talk of consultation with the executive. You say Article 124(2) earlier. The president shall appoint after consultation with Supreme Court and High Court. It doesn't say after consulting the executive. Consultation only with the judges to get the best possible names. That is the purpose of 124(2). I don't see how the Collegium system is something coming from heaven which nobody thought of. The only thing in the Collegium system is that they have made a kind of a standard operating procedure. How does the system work? The first 3 judges of the court, recommendations are made, then it goes step-by-step processes are mentioned. Then first recommendation, second, all that has been elaborated. But is this not a consultation with the judiciary by itself? Yes. And this criticism from the law minister, vice president was, I think, unfortunate, because it was not fair to say that the Supreme Court should not strike down NJC because it was passed unanimously by Parliament. The 42nd Amendment was passed unanimously by Parliament. So you don't strike down the 42nd Amendment? The Privy Purses was unanimously by Parliament. You don't strike it down. I mean, not unanimous, but by substantial majority. The whole purpose of judicial review is, even though 100 out of 100 legislatures say so, executive strikes it down. And that judiciary strikes it down. That happens in the US also.
And now the Supreme Court is seized of the matter regarding judicial appointment. And the Supreme Court is now seized of the matter, a petition concerning judicial appointments. And
the only thing was, the main petition is for having some timeline. See, if the 9 judges bench, if you see the 9 judges bench, at the opening of the judgment, the Attorney General said that Union of India accepts that this is the appointment procedure. That has been accepted by the Union.
Right.
So today the MOP is the procedure with T capital.
Right.
But unless you bring in a new legislation by amending the Constitution, you can't. And I'm saying, why have a new law? Just sit down and tweak the MOP procedure. Tell the court what points the executive feels is interfering with their right of choosing the best, or their process of consultation with them also. What consultation do you want? What is the extent of say you want?
Right now, but
I don't see, but you see, neither the vice president nor the law minister has really come out by simply saying that the judiciary is going against the will of parliament. See, these are all general terms which can go to the newspaper, but when you're talking of serious stuff, you must go into great detail as to what is the violation, what is the irregularity, how can it be addressed under the constitution, under a parliamentary law. All those things that to be addressed. Just simply saying judiciary is high-handed, judiciary is overreaching. All these are all vague terms. You know?
Right now, there are some clear instances of the government acting in violation of the Supreme Court directions. For example, the Collegium reiterations, they are not acted upon; they are sent back. And sometimes the Collegium resolutions, they are segregated, and some names are approved and some names are kept pending. So, and the court is now on the judicial side; it's seized of a contempt petition. And so, how do you think the court should resolve the issue? Should there be a strong direction on the judicial side, or mere oral observations and nudging and persuasion, will that suffice? Or has the time come for the judiciary to step its foot down and pass some strong orders?
It's very sad. You see, you say that judiciary is the least dangerous branch. It is also perhaps the weakest branch, because except power of contempt, what do they have? You send a name and you don't keep it pending for 3 years and 2 years. What does the judiciary do? They can't issue a mandamus to the president that you'll sign the warrant. Suppose they issue a mandamus, president doesn't sign, what happens? You see, this is where I think the issue of constitutional morality comes in. Constitutional convention should be followed. Now, from last 30 years, there is a law saying that after the first objection, if the Supreme Court reiterates its position, then the appointment should go through. That is the procedure established by law. It is binding under Article 141. If after your objections are given, Supreme Court considers it, they give a written, detailed reasons why they are not accepting the objection. Then what is the difficulty in appointing again? If you say the standoff, I don't think the judiciary can do anything. I mean, by the executive not appointing, whom are you damaging? It's a self-inflicted wound, in my opinion, in the long run. Today, you may ensure that X or Y, whom you don't like, doesn't come, or A, B, C, whom you like very much, comes within 2-3 days. But then you think of what you're doing to the judiciary as a whole, and down the line, what is the message you're passing now? You're passing a message to the other judges that, look, any unfavorable judgment, anything against the powers that be, is going to be a stumbling block on your progress. Every High Court judge will definitely want to be a Chief Justice Supreme Court. That's natural human tendency. But if you're going to convey the message that fearlessness, adherence to constitutional values, giving a bold, independent judgment is going to be counterproductive, it's a very sad state of affairs. And you know what happened after Indira Gandhi did that, right? Did it help our judiciary?
And
it's only after the emergency that the judiciary went back, and then this PIL concept came, and again that was there because of the post-Janata government came to power. But the long-term damage done by Mrs. Gandhi is phenomenal. In 42nd Amendment, supersession of judges, the rot's really set in there. And the reverberations have been felt for decades.
Right. And as a final comments, what do you think, or what are, in your opinion, what could be the reforms which the collegium system could have?
See, according to me, at present, the only thing that can be done to make the collegium system work is to fix timelines. That from the Collegium, High Court makes a recommendation. Every state, it should be time 4 weeks, 8 weeks. That's one thing I can immediately recommend. I think there is enough of consultation with the executive. Right. Secondly, I would also prefer that when the executive gives objection and it is considered, then the name should not be kept pending. So once timelines are fixed, the collegium can work. The only other option, if you don't want the collegium at all, then have the NJC as recommended by the Venkatachalaya committee. That commission can work. Yeah.
Right.
In fact, when I filed the name, when the Madras Bar Association filed a PIL for fixing timelines, Justice, the Supreme Court dismissed it on the ground. It's premature. Let us see later. But I think the time has come by just fixing timelines. And you see, from the point of suppose, like Manu Sebastian is recommended as a judge. Now, what do you continue your practice? The name has been approved by the Collegium. It goes for approval. Now, earlier when I was a junior, once your name is approved, once your name has been recommended, you stop practice. I know some lawyers who have stopped practice. This is before the present government in the 90s. 7 months, there was some delay for some reason or the other. They couldn't practice for 7 months. So, if I'm a lawyer having a reasonable practice and I accept the request and I take it as a privilege, honor, be a judge, and my name is not approved for 12 months, 14 months, what do I do? Then other person will say, why should I unnecessarily face the embarrassment? My name goes and not recommended. Then people start saying, why is his name not recommended? Or now is his name not approved? So many questions are asked. It's embarrassing for that person also. So I think timeline will be the most important thing in my opinion.
Right. So
and
thank you.
Let the Collegium system continue.
Thank you so much, sir, for sharing your views. Thank you so much.
Thank you. Wish all of you a happy new year. Thank you.